Welcome back, everybody, to our studies in the law of tort. In this lesson, we are moving on to the next major topic, which is, of course, in relation to the subject of vicarious liability. Now, I noted in a previous lesson that vicarious liability is quite similar to that of employer's liability. In a certain regard, it is quite similar. It involves the kind of employment relationship and when a duty may arise in certain circumstances, but of course there are clear differences that exist in relation to who and to where a duty of care is owed by an employer in various different circumstances, as we shift away from employer's liability to this idea of vicarious liability. So in previous lessons, the previous topic, topic 5, we spoke about the liability that can be derived as the result of being an employer in their duty of care to protect employees. In this lesson, we're going to talk about vicarious liability, which is a different type of liability, but also relates to a relationship between an employer, an employee, and a third party. That's the key difference in relation to employer's liability on the one hand and then vicarious liability on the other. Because whereas employer's liability relates to the duty of care that is imposed on an employer in relation to his or her employees, what vicarious liability talks about is the fact that there is a duty of care on an employer that they have in relation to a third-party claimant who will then suffer as the result of the actions of an employee. So not only does an employer have a duty of care towards their employees, this is employer's liability, but an employer also has a duty of care to third-party claimants who may suffer from some kind of damage as the result of actions on the part of their employees who they are employing. This is what vicarious liability tells us. So essentially, what vicarious liability does is it assumes a responsibility on the part of an employer to the actions of his or her employees. So why is it vicarious liability? Well, given that this involves essentially handing over liability to an individual who isn't directly responsible for the commission of a tortious action, why is it the case that vicarious liability even exists? Why does vicarious liability exist? Given the fact that we're not talking anymore about the actions of an employer, which then gives rise to a duty of care to employees or to any other individual, we're talking about the actions of an employee towards a third party, and how, in that circumstance, does an employer retain some kind of duty towards this third party as the result of the actions of an employee? Well, given the fact that the employer is seen to have a certain amount of extensive control over the actions of their employees, it is seen that the actions of the employee isn't entirely their own action. They aren't entirely of their own doing in a lot of circumstances. They will be following the will as well as the direction and, in some circumstances, the direct command of their employer. So if an employer directs and commands one of their employees to perform a certain action or to do something that gives rise to tortious liability and essentially causing some kind of damage or harm to a third-party claimant, then really should it be the case that the employer suffers from no liability in tort because they could just argue, well, it wasn't me who did this, it was my employee who did this? Of course, the response is, well, no, your employee was acting upon your direction to do this, that, and the other. Therefore, you should have a certain amount of liability imposed onto you as the result of the fact that your employee was following your direction. You have a certain amount of liability, and this liability is, therefore, vicarious liability. In addition to this, given that the employer essentially stands to profit from the actions of their employees, it makes sense to suggest that given the fact that they both have control over the actions of their employees in the performance of their employment relationship, And in addition to this, they stand to profit from the actions of their employees, they should also be able to bear some of the risks that are attached to the actions of their employees, which could then give rise to damage caused to a third-party claimant. So how does one show vicarious liability? Now that we have properly justified the existence of vicarious liability and given a couple of reasons why vicarious liability it should exist, or at least ought to exist in certain circumstances, how does one actually show that vicarious liability exists? Well, we shall get into this in more detail in the next few lessons, but of course we will talk a little bit about the main elements and the main requirements for vicarious liability here, just at this initial venture. Essentially, there are three main requirements that are necessary to show the existence of vicarious liability, or for a claim in vicarious liability to have the potential to be successful. There must first actually be a tort committed, or it can be done through an omission. So the tort itself must actually exist, and obviously have caused damage to a third party. The tort must have been committed, or it must have been an omission, by an individual who has an employment relationship with the employer. And then finally, the tort must have been committed in the course of an employment, rather than being committed outside of work hours / work obligations. So, firstly, there has to have been a tort. That's relatively easy to understand, okay? And you just would apply the basic principles of torts to show the negligence or any other tort in that particular context. That is essentially whereby the employee is a defendant and the third party claimant is the claimant. That tort must have been committed, or it must have been done through an omission, by an individual who has some kind of employment relationship with an employer. We'll get to the circumstances in which this can take place in the future, because of course there are various different employment relationships, and so the courts have had to approach this in various different ways. And then finally, to avoid an employer being liable for any kind of tortious activity by the employee, the tort must have been committed in the course of the employment. So essentially this protects against an employer employing some employee, and then for this employee to go out for maybe on a night out outside of office hours and commit some tort against an individual. Maybe they assault someone, and then this third party victim on this night out goes and tries to sue the employer. Of course, the employer shouldn't be liable for the actions of their employees outside of work hours and outside of work obligations. That would be a bit silly as well. So as a result of this, it is only up to the course of the employment that we see that a vicarious liability should arise. Welcome back, everybody, to the law of tort. In this lesson, we are continuing talking about the idea of vicarious liability, looking at the ways in which we can show vicarious liability in particular circumstances. Now, at the end of the previous lesson, what we did was introduce what are considered to be the most the main requirements, the three main requirements which are needed to show an instance of vicarious liability against an employer. And this lesson, as you would probably imagine, is going to unpack these ideas in a little bit more detail. And so fundamentally, when it comes to showing vicarious liability, we have to show those three circumstances. Remembering back to the previous lesson, the three major elements to show an instance of vicarious liability are as follows. Firstly, there has to exist some tortious action and or omission. Some kind of tort has to have taken place or had failed to take place that gives rise to tortious liability. Often it is obviously the former rather than the latter. There also has to exist an employment relationship. So the tortious action has to have been committed by an employer who is in an employment relationship. Finally, the tortious action or omission has to have been done in the course of the employment. And if you remember back, vicarious liability is essentially the liability that an employer may have towards a third party for the actions of their employees. So if I'm an employer and I hire somebody to do a thing, and in the course of that employment, the employee, starts to and commits some kind of tortious action, then because I have an employment relationship with that employee, because it was done in the course of the employment, then I may have a vicarious liability towards the victims or the claimants of that particular tortious action. Now, these are, for the most part, relatively uncontroversial elements, and so really it's not going to take us that long to get through this particular area of the law. The existence of tortious actions and or omissions. Let's begin with this one. Of course, the first step is to show that the employee had acted in a way which would derive liability in the law of tort. So depending on the tort that we're talking about, whether it is negligence, whether it's maybe defamation or something like that, you have to, of course, satisfy those individual elements of liability for that particular tort. So, for example, if it is negligence, you have to show that there was a duty of care, you have to show that there was a breach of a duty of care, then you have to show, of course, that there was causation, and of course it wasn't too remote, and then there you go, you have your tortious liability. For the most part, it will be the tort of negligence, but of course it does not necessarily have to be the tort of negligence. It could be any tort, theoretically. So that's the easiest thing to conclude. Very easy to understand. You have to show that there is an existence of some kind of tortious action or omission. The next place that we have to go to is the idea of an employment relationship. So this takes us away from the ordinary course of the law of torts, where just an individual that has committed a tort and you have to show the tort, to the idea of vicarious liability. We have to make the jump now from not only is there liability on the employee, but there may be also liability on the employer for the actions of the employee. And in order to do that, you have to show that there existed an employment relationship. You have to show that there is a connection between the employee and the employer. Now, this element, of course, requires a little bit more detail and examination than the previous one. We shall briefly overview this in this video before talking about the key tests for showing an employment relationship in the next. So this is going to be basically overviewed in this video, and then in the next video we'll talk about it in more detail. Because fundamentally, this is the key question, whether or not there was an employment relationship. And there's the reason why this is a little bit more controversial than the previous case or the previous examination was that fundamentally, an employment relationship is quite a broad concept. It is a concept that could include a variety of different kinds of relationship and could look like lots of different types of relationships. And so as a result of that, there's a little bit more detail and examination in determining where the idea of an employment relationship begins and ends, for example. Simply put, it must be shown that the individual in question who has committed the tortious action was actually an employee of the employer. This can be shown through a variety of different means, and this is the kind of evidence that you would think so. So, for example, the existence of an employment contract. Very easy. If there is an employment contract, they performed this tortious action in the course of performing that contract, then therefore, and there was a tortious action obviously in the first place, then the employer could be liable in the case of vicarious liability. But you also have instances where there is maybe an independent contractor. This is really a difficult one because in this case it would be quite rare for vicarious liability to be valid, therefore for there to be any vicarious liability for their actions. So it's a little bit more complicated. Like I said, we'll talk about this in a little bit more detail, looking at some case law in the next lesson. The final point, of course, is this idea of the tortious activity that exists within the employment relationship took place during the course of the employment. This is to essentially leave out and leave on the cutting room floor all of the elements of liability that could arise if you just had if you had an individual who you were employing who then went out and did some tortious action when they were not at work and they were not performing any kind of employment in the course of their employment. So, for example, if you employed an individual and then they went out on a night out after work and ended up assaulting an individual, somebody else, you cannot be liable in vicarious liability for the tortious action of that assault, because of course it wasn't performed in the course of the employment. So how could you attach any liability for that? So that's what I've essentially just encapsulated here. The purpose of this element is to ensure that the action that is actually committed is committed during the time of employment, rather than it just being any kind of activity, whether it be committed by the employee, private or otherwise, at any point in time. To allow the latter would essentially to ensure the employer had control over the private life of their employees, and it would also ensure that the employee had very little free will over their actions, given the fact that it would be ultimately the employer that has attached some kind of liability as well. So it is important that, of course, that this is a key test and a key requirement that takes place during an instance of vicarious liability. As I mentioned in the previous video, what we're going to do here is talk a little bit more about the second element of the requirements for the showing of vicarious liability. And this is obviously the idea of the employment relationship. Now, we talked in previous lessons about the other elements of vicarious liability, the fact that there has to firstly be tortious action on the one hand by an employee, the fact that there has to be a relationship that is an employment relationship between the employer and the employee, which we'll get to in this video, but that there also has to have had the tortious action have been committed throughout the conduct and the course of the employment, rather than in any kind of other setting, let's say in their private life. Like I said, the main elements are these: the tortious activity and employment relationship, and the tortious activity being committed during the course of the employment. This video is going to spend a little bit more time talking about the second of these elements. We only really touched on it in the previous lesson because this is the most complicated, arguably the most important to examine. Reason for this is, of course, because employment relationship as a broad category is, as the name suggests, as I've just suggested, it is quite broad. It is quite a vague categorization, and so as a result of this, we need to essentially unpack this idea in a little bit more detail to really get to the heart of how we could define an employment relationship. So, when it comes to establishing an employment relationship, the process of establishing has often required more than just the simple reference to an employment contract. In some circumstances, it is just the case that there is an employment contract. It is very clear that it is a bog standard relationship of employment. It is a bog standard action that had been committed during the course of that employment, and it was a tortious activity that gives rise to vicarious liability as a result. They're the easy cases. They're the cases that are often very easy to understand, very simple, and often aren't even cases that get to court because they're often settled outside of court because it would be a waste of time. So, what about the more complicated ones? The ones that is not referencing an employment contract? Really, these are the ones that involve an examination of the specific relationship in question, as well as the facts of the particular case in question. And so with that being said, the courts have established a number of different tests to make determinations as to the nature of the employment relationship. It is often not as simple as just referencing an employment contract. It is a little bit more complicated than this. The first of these is reference to this idea of control tests. Control tests were more of a historical way of approaching the issue of employment. Essentially, the control test tells us that if there was an element of control that an employer had over the alleged employee, then this would be representative of some kind of employment relationship. So it doesn't necessarily matter if there was an employment contract, or if there was any other kind of situation of that nature that may or may not give rise to an employment relationship, so long as there is some kind of work taking place and it is being done with a certain element of control between one person and another person, then it is considered that this is an employment relationship. and so as a result of which the control test examines it on the basis of that particular instance. Today, however, a control test is only one metric. It is only one way in which we can actually satisfy an employment relationship for vicarious liability. It's not even one that is necessarily satisfied, given that some circumstances there may be an employment relationship, but there is very little control over the actions of an individual. And so as a result of which, to suggest that control is the only way in which we should be able to measure such an instance of employment relationship is a little bit dubious, shall we say. Continuing on then, there is this second test that we can think about. This is something known as the composite test, or the composite test. It's a more updated approach, and essentially what the composite test tells us, as the name suggests, requires something of a holistic approach, essentially examining the employment relationship by not necessarily referencing an employment contract or a certain amount of control, but by examining the facts of that particular case and examining lots of different ways in which it is approached. So a good application of the composite test is illustrated in the following case. This is the case of Market Investigations Limited versus the Minister of Social Security. This is a case from 1969. And it illustrates the point of the composite test. It illustrates the way in which the composite test actually operates in the circumstances in question. Essentially, the facts of this case was that of an employment relationship, which was one for a woman who had acted as an interviewer for a company which was performing market research obligations. She was not always relied upon in the role, since she would only perform interviews on an irregular basis. So it's quite a loose and quite a lax employment relationship, if it is even an employment relationship at all. She would be under significant control from the company, but she also did not receive sick pay. So there were certain elements of this particular relationship where you could point to it being an employment relationship. So, for example, being under significant control from the company. But then there was also instances where you would maybe argue that it was not an employment relationship. For example, an interviewer for a company, but only being relied upon for irregular basis on an irregular basis, and also not receiving sick pay, which is of course a statutory requirement for employers. The question for the court, therefore, was whether or not this represented an adequate employment relationship for the standard required to establish the second limb of the test for vicarious liability, this being the test of there being an employment relationship, and not just an independent contractor. Because when we talk about independent contractors, it is very likely that there would not be an instance of vicarious liability in those particular circumstances. In application of less than a control test and less of reference to an employment contract, but more so to a composite test, the courts took into account the relevant elements, all of the relevant elements, and they concluded that she was not just an independent contractor, but they concluded that she was an employee. So it is often the case that in the more complicated and the more nuanced examples, the more nuanced cases, that it would be concluded, therefore, that the individual has to, or the court, should I say, have to rely on a variety of different factors. The composite test requires a number of different factors, rather than just asking whether or not they had significant control, whether or not they received statutory sick pay, whether or not she had a contractual obligation, as in an employment contract, whether or not she would be relied upon in the role for particular purposes, all of which makes you come to a conclusion that is a lot more holistic in terms of an approach, rather than a one-size-fits-all approach which had been established in previous cases.